In the previous section, that is lesson 3, part 3, subpart 2, we addressed the power of arrest without a warrant. We zeroed in on the provisions of the law that regulate how the police, judicial officers, and private persons can exercise the power of arrest without a warrant. In this section, we will address the power of arrest with a warrant. Wikipedia defines the term as a warrant issued by a judge or magistrate on behalf of the state, which authorizes the arrest and detention of an individual or the search and seizure of an individual's property. The practice in Nigeria is similar to the practice in England and Wales that permits the issuance of arrest warrants for both suspects and witnesses. In one sentence, an arrest warrant or warrant of arrest is a court order issued to a police officer or officers directing him or them to arrest a named person. What are the provisions of the ACJA on warrant of arrest? Section 37 of the ACJA states, a warrant of arrest shall not be issued in the first instance in respect of any complaint or statement unless the complaint or statement is on oath by the complainant himself or by a material witness. But see also section 132 of the ACJA, which states, where a complaint is before a magistrate, as provided in this act, and the magistrate decides to issue a warrant, he shall issue a warrant to arrest the suspect and bring him before the court to answer the complaint and be dealt with according to law. Next in line are the provisions of the ACJL on warrants of arrest. Section 23 of the ACJL states, no warrant of arrest shall be issued in the first instance in respect of any complaint or statement unless made in writing on oath by the complainant himself or by a material witness. But see also section 95 of the ACJL, which states, whereupon a complaint being made before a magistrate as provided for in section 23, such magistrate decides to issue a warrant in the first instance, such magistrate shall issue a warrant to apprehend the person complained against, to bring him before the court, to answer the said complaint, and be dealt with according to the law. What are the provisions of the CPA on warrants of arrest? Section 23 of the CPA states, no warrant of arrest shall be issued in the first instance in respect of any complaint or statement unless such complaint or statement be on oath, either by the complainant himself or by a material witness. But see also section 97 of the CPA, which states, whereupon a complaint being made before a issue of magistrates as provided in section 23 of this act, such magistrate decides to issue a warrant in the first instance, such magistrate shall issue a warrant to apprehend the person complained against and to bring him before the court to answer the said complaint and be dealt with according to the law. Finally, let's consider the CPC's provisions on warrants of arrest. The CPC does not have provisions that may be said to be on all fours with the two sections we have quoted from the ACJA, the ACJL, and the CPA respectively. The closest provisions appear to be sections 143D and E and sections 146 subsection 1 and 2. Let's take a look at each of them. Section 143 states, subject to the provisions of Chapter 13 and 14, and to any limitation on the powers of the court, a court may take cognizance of an offense. Section 143D states, upon receiving a complaint of facts which constitute the offense. Section 143E states, if from information received from any person other than a police officer, it has reason to believe or suspect that an offense has been committed. Section 146 subsection 1 states, a court taking cognizance of an offense and complaint shall, subject to the exercise of its powers under sections 144 and 145, thereupon examine the complaint and reduce his complaint and the substance of the examination to writing. And the writing shall be signed or sealed by the complainant if he is able so to do. Section 146 subsection 2 states, a court may in its discretion conduct such examination on oath. It is on the basis of the above provisions of the CPC's jurisdiction. The following is often said. 1. That a warrant of arrest is issued upon complaint which need not be on oath. 2. That the complaint is not required to be in writing. 3. That the complaint need only disclose the commission of an offense. Who issues a warrant of arrest? Who has the authority to issue a warrant of arrest? How can a warrant of arrest be procured? Under the ACJA, by virtue of section 36 subsection 1 of the ACJA, only a judge or magistrate. Within the ACJA jurisdiction, it must be written and signed and issued upon a complaint or statement on oath. See section 37 of the ACJA. Within the ACJL jurisdiction, by virtue of section 22 subsection 1 of the ACJL, only a judge or magistrate. Within ACJL jurisdiction, it must be written and signed and issued upon a complaint or statement on oath and made in writing. See section 23 of the ACJL. Within CPA jurisdiction, by virtue of section 22 subsection 1 of the CPA, only a judge or magistrate. Within CPA jurisdiction, it must be written and signed and issued upon a complaint or statement on oath. Within CPC jurisdiction, by virtue of section 56 subsection 1 of the CPC, only a court or justice of the peace can. But then section 1 of the CPC defines court to mean any court of civil or criminal jurisdiction established by any law or deemed to be so established. Therefore, court includes any judge or magistrate. Within CPC jurisdiction, it must be written, but can either be signed or sealed and issued upon a complaint that need not be in writing nor be on oath. See section 56 to 66 of the CPC. Also note that within the CPC jurisdiction, a magistrate can issue a warrant of arrest even where the magistrate does not have the jurisdiction to try the alleged offender under the CPC. And the reference for that is section 63 of the CPC. It is important to note that no police officer, irrespective of rank, can issue a warrant of arrest. The judge or magistrate can only properly issue a warrant of arrest while sitting in his capacity as a judge or magistrate. And the reference for that is the case of Ikonne versus the Commissioner of Police. Who is authorized by law to execute a warrant of arrest? Basically, two classes of persons. The first class is a police officer or all police officers. Section 39, subsection 1 of the ACJA states in part, a warrant of arrest may be directed to a police officer by name or all police officers. Section 25, subsection 1 of the ACJL states in part, a warrant of arrest may be directed to a police officer by name or to all police officers. Section 25, subsection 1 of the CPA states in part, a warrant of arrest may be directed to a police officer by name or to all police officers, or to a police officer by name and to all police officers. Section 58 subsection 1 of the CPC states, a warrant of arrest shall ordinarily be directed to one or more police officers or other public servants who may be authorized to make an arrest. The second class of person is any other person. Section 40, subsection 1 of the ACJA reads, a court issuing a warrant of arrest may, where its immediate execution is necessary and no police officer is immediately available, direct it to some other person or persons, and the person or persons shall execute the same. Section 26, subsection 1 of the ACJL states, a court issuing a warrant of arrest may, if its immediate execution is necessary and no police officer is immediately available, direct it to some other person or persons, and the person or persons shall execute the warrant. Section 27, subsection 1 of the CPA states, any court issuing a warrant of arrest may, if its immediate execution is necessary and no police officer is immediately available, direct it to some other person or persons, and such person or persons shall execute the same. Section 58 subsection 1 of the CPC states, a warrant of arrest shall ordinarily be directed to one or more police officers or other public servants who may be authorized to make an arrest, but the court or justice of the peace issuing the warrant may, if its immediate execution is necessary and no police officer or other public servant so authorized is immediately available, direct it to any other person or persons. Time of issuance of a warrant of arrest. Section 38 of the ACJA tells us on any day, Sunday inclusive, public holiday inclusive. Section 24 of the ACJL tells us on any day, Sunday inclusive, public holiday inclusive. Section 24 of the CPA tells us on any day, Sunday inclusive, public holiday inclusive. The CPC does not have a provision that is as explicit as the other jurisdictions. The nearest such provision is Section 90 of the CPC, which is of limited application. It applies to the issuance of a warrant of arrest if a breach of peace is likely. According to that section, such justice of the peace may at any time issue a warrant for the arrest of such person and for his production before the court. Time of service or execution of a warrant of arrest. Section 43 of the ACJA tells us on any day, Sunday inclusive, public holiday inclusive. Section 27 of the ACJL tells us on any day, Sunday inclusive, public holiday inclusive. Section 28 of the CPA tells us on any day, Sunday inclusive, public holiday inclusive. The CPC appears not to have a similar provision at all. When does the judicial arm of government resort to or employ warrants of arrest in an attempt to dispense justice? A warrant of arrest may be issued or employed or resorted to in the following circumstances. 1. The statute creating the offense specifies that an offender cannot be arrested without the presentation of a warrant of arrest. 2. If someone to whom a summons is addressed is guilty of abscondment or concealment, that is interference with the execution of the warrant of arrest. Please see Section 131 of the ACJA, Section 94 of the ACJL, Section 96 of the CPA, and Section 70 of the CPC. Some textbooks include as a third reason where a serious offense is alleged against the offender. What are the provisions of the ACJA on the lifespan of a warrant of arrest? Section 39 subsection 2 of the ACJA states, it is not necessary to make a warrant of arrest returnable at any particular time, and a warrant of arrest shall remain in force until it is executed or until a judge or a magistrate cancels it. Section 139 of the ACJA states, a summons, warrant of any description or other process issued under a law shall not be invalidated by reason of the person who signed the summons or warrant being dead, ceasing to hold office, or have jurisdiction. Section 136 of the ACJA states, where a defendant is before a court, whether voluntarily or on summons, or after being arrested with or without warrant, or while in custody for the same or any other offense, trial may be held notwithstanding a. Any irregularity, defect, or error in the summons or warrant, or the issuing, service, or execution of the summons or warrant, b. the want of any complaint on oath, or c. any defect in the complaint or any irregularity in the arrest or custody of the defendant. What are the provisions of the ACJL on the lifespan of a warrant of arrest? Section 25, subsection 2 of the ACJL states, it shall not be necessary to make any such warrant returnable at any particular time, and a warrant shall remain in force until it is executed, or until it is cancelled by a judge or magistrate, as the case may be. Section 100 of the ACJL states, a summons or warrant or other process issued under any written law shall not be invalidated by reason of the death of the person who signed the same, or his ceasing to hold office or have jurisdiction. Section 98 of the ACJL states, when any defendant is before a magistrate, whether voluntarily or upon summons, or after being arrested with or without warrant, or while in custody for the same or any other offense, trial may be held notwithstanding any irregularity, defect, or error in the summons or warrant, or the issuing, service, or execution of the same, and notwithstanding the want of any complaint upon oath, and notwithstanding any defect in the complaint, or any irregularity, or in the arrests or custody of the defendant. What are the provisions of the CPA on the lifespan of a warrant of arrest? Section 25, subsection 2 of the CPA states, it shall not be necessary to make any such warrant returnable at any particular time, and a warrant shall remain in force until it is executed, or until it is cancelled by a judge or a magistrate, as the case may be. Section 103 of the CPA states, a summons, warrant of any description, or other process issued under any written law shall not be invalidated by reason of the person who signed the same dying, ceasing to hold office, or have jurisdiction. Section 101 of the CPA states, when any accused person is before a magistrate, whether voluntarily or upon summons, or after being apprehended with or without warrant, or while in custody for the same or any other offense, the preliminary inquiry or trial may be held notwithstanding any irregularity, illegality, defect, or error in the summons or warrant, or the issuing, service, or execution of the same, and notwithstanding the want of any complaint upon oath, and notwithstanding any defect in the complaint, or any irregularity or illegality in the arrest or custody of the accused person. What are the provisions of the CPC on the lifespan of a warrant of arrest? Section 56 subsection 2 of the CPC states, every such warrant shall remain in force until it is cancelled by the court or justice of the peace issuing it, or until it is executed. Section 383 of the CPC states, a summons, warrant, or other process under any written law shall not be invalidated by reason of the person who signed the same dying or ceasing to hold office or have jurisdiction. Section 382 of the CPC states, subject to the provisions herein before contained, no findings, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered on appeal or review on account of any error, omission, or irregularity in the complaint, summons, warrant, charge, public summons, order, judgment, or other proceedings. Before or during trial, or when any inquiry or other proceedings under this Criminal Procedure Code, unless the appeal court on reviewing authority thinks that a failure of justice has in fact been occasioned by such error, omission, or irregularity. Contents of a warrant of arrest. Number 1, it must be dated. Number 2, it must be signed by the issuing authority. Number 3, it must contain a brief account of the alleged offenses. Number 4, it must name the alleged offender or succinctly describe the alleged offender. Number 5, it must contain a directive to any or more of the following. 1, a police officer by name. 2, all police officers. 3, one or more police officers. 4, other public servants. And 5, any other person. 6, it must be written. And 7, it must be in duplicate. Our authorities are Section 36 subsection 1 and 2 of the ACJA, Section 22 subsection 1 and 2 of the ACJL, Section 22 subsection 1 and 2 of the CPM, and Section 56 subsection 1 and 2 of the CPC. What are the key provisions on 1, day of execution of a warrant of arrest? 2, time of execution of a warrant of arrest. 3, place of execution of the warrant of arrest. 4, procedure for execution of a warrant of arrest. 5, the court that has jurisdiction over a person arrested on a warrant of arrest. Let's consider the ACJA first. Section 43 subsection 1 of the ACJA has this to say about the day of execution of a warrant of arrest. A warrant of arrest may be executed on any day, including a Sunday or public holiday. Section 43 subsection 2 of the ACJA has this to say about the time and place of execution of a warrant of arrest. A warrant of arrest may be executed by any police officer at any time and in any place in any state other than within the actual courtroom in which a court is sitting. Section 43 subsection 3 of the ACJA has this to say about the procedure for execution of a warrant of arrest. The police officer executing a warrant of arrest shall, before making the arrest, inform the suspect to be arrested that there is a warrant for his arrest unless there is reasonable cause for abstaining from giving the information on the ground that it is likely to occasion escape, resistance, or rescue. Section 43 subsection 4 has this to say about the court that has jurisdiction over a person arrested on a warrant of arrest. A suspect arrested on a warrant of arrest shall, subject to the provisions of the Constitution of the Federal Republic of Nigeria, sections 44 and 45 of this Act, be brought before the court that issued the warrant of arrest. Next in line is the ACJL. Section 27 subsection 1 of the ACJL has this to say about the day of execution of a warrant of arrest. Every warrant of arrest may be executed on any day including a Sunday or public holiday. Section 27 subsection 2 of the ACJL has this to say about the time and place of execution of a warrant of arrest. Every such warrant may be executed by a police officer at any time and in any place other than in a courtroom in the state. Section 27 subsection 3 of the ACJL has this to say about the procedure for execution of a warrant of arrest. The person executing the warrant shall, before making the arrest, inform the person to be arrested that there is a warrant for his arrest, unless there is reasonable cause for abstaining from giving such information on the grounds that it is likely to occasion escape, resistance, or rescue. Section 27 subsection 4 of the ACJL has this to say about the court that has jurisdiction over a person arrested on a warrant of arrest. Every person arrested on the warrant shall, subject to the provisions of section 29 and 30 of this law, be brought before the court which issued the warrant within a reasonable time after he is so arrested. Now let's move on to the CPA. Section 28 subsection 1 of the CPA has this to say about the day of execution of a warrant of arrest. Every warrant of arrest may be executed on any day including a Sunday or public holiday. Section 28 subsection 2 of the CPA has this to say about the time and place of execution of a warrant of arrest. Every such warrant may be executed by a police officer at any time and in any place in the state other than within the actual courtroom in which a court is sitting. Section 28 subsection 3 of the CPA has this to say about the procedure for execution of a warrant of arrest. The person executing any such warrant shall, before making the arrest, inform the person to be arrested that there is a warrant for his apprehension unless there is reasonable cause for abstaining from giving such information on the ground that it is likely to occasion escape, resistance, or rescue. Section 28 subsection 4 of the CPA has this to say about the court that has jurisdiction over a person arrested on a warrant of arrest. Every person arrested on any such warrant shall, subject to the provisions of Section 30 and 31 of this Act, be brought before the court which issued the warrant as soon as is practicable after he is so arrested. In the CPC jurisdiction, the law is silent on the issuance or execution, that is service of a warrant of arrest. So, what are the key take-home points? In ACJA jurisdiction, ACJL jurisdiction, and the CPA jurisdiction, it can be executed on any day, Sundays, and public holidays inclusive. Although the CPC is silent, it would seem that the above is the rule of practice in that jurisdiction. Where a warrant of arrest is issued in one state, that is the issuing state, to be executed in another state, that is the state of execution, the procedure is as provided for in Section 46 subsection 1 of the ACJA, Section 30 subsection 1 of the ACJL, Section 31 subsection 1 of the CPA, and Section 64, 65, and 66 of the CPC. Section 46 subsection 1 of the ACJA states, where a warrant of arrest is executed in a state outside the division or district of the court by which it was issued, the suspect shall, unless security is taken under Section 45 of this Act, be taken before the court within the division or district in which the arrest was made. Section 30 subsection 1 of the ACJL states, Where a warrant of arrest is executed in the state outside the division or district of the court by which it was issued, the person arrested shall, unless security is taken under Section 29, be taken before the court within the division or district in which the arrest was made. Section 31, subsection 1 of the CPA. Where a warrant of arrest is executed in the state outside the division or district of the court by which it was issued, the person arrested shall, unless security is taken under Section 30 of this Act, be taken before the court within the division or district in which the arrest was made. Section 64, subsection 1 of the CPA states, when a warrant of arrest is to be executed outside the local limits of the jurisdiction of the court or justice of the peace issuing it, such court or justice of the peace may, instead of directing such warrant as laid down in Section 58, forward it by post or otherwise to any court within the local limits of whose jurisdiction it is to be executed. Section 64, subsection 2 of the CPC states, such court shall endorse the warrant and, if practicable, cause it to be executed in manner hereinbefore provided within the local limits of its jurisdiction. Section 65 of the CPC states, when a warrant of arrest is to be executed beyond the local limits of the jurisdiction of the court or justice of the peace issuing it, the person to whom it is directed shall take it for endorsement to a court within the local limits of whose jurisdiction the warrant is to be executed. Section 66, subsection 1 of the CPC states, when a warrant of arrest is executed outside the local limits of the jurisdiction of the court or justice of the peace issuing it, the person arrested shall, unless security is taken under Section 57, to be taken before a court within the local limits of whose jurisdiction the arrest was made, and such court shall, if the person arrested appears to be the person intended by the court or justice of the peace issuing the warrant, either A, take security for his appearance in accordance with the provisions of Chapter 29, or as directed by an endorsement of the warrant under Section 57, and forward the bond or bonds to the court or justice of the peace issuing the warrant, or B, direct his removal in custody to such court or justice of the peace. Section 66, subsection 2 of the CPC states, notwithstanding the provisions of subsection 1, the arrested person may be taken directly before the court or justice of the peace issuing the warrant, if this course is more convenient having regard to conditions of time, place, and other circumstances. We shall now turn our attention to the execution of a warrant of arrest outside the state of issue. This is a step-by-step procedure, which is different depending on ACJA, ACJL, CPA on the one side, and the CPC on the other side. And by difference, we mean that what obtains in the ACJA, ACJL, and CPA jurisdictions is what is known as a rule of law. What obtains in the CPC jurisdiction is what is known as a rule of practice. Step 1. A police officer will assist the issuing court transmit the warrant of arrest to the executing court, which has jurisdiction in the state of execution. Step 2. A judge or magistrate in the state of execution shall endorse the warrant of arrest if the following conditions are true. 1. That the court of competent jurisdiction issued it. 2. That the offense is known to law in the state of issuance. The authority for this position is R versus Olu. Please take note of the following additional points. The court reserves the right to refuse to endorse the warrant if both conditions are unmet. The authority for this is Commissioner of Police versus Apampa. 2. Endorsement by the executing court is the legal authorization for the police officer to execute the warrant of arrest. The authority for this is once again Commissioner of Police versus Apampa, as well as Section 482 subsection 2 of the CPA and 365 subsection 2 of the ACJL. 3. Making an endorsement is a ministerial act, but the making of orders is a judicial act. Metropolitan Police Commissioner versus Hammond. Step 3. The executing court, that's the endorsing court, after arresting the person, may 1. Order that the offender be discharged if the offense he is charged is unknown to law in the state of issuance. 2. Approve or reject bail bond, and thereafter forward the arrested person to the issuing court. See Section 482 subsection 3 of the CPA. Step 4. If the arrested person is uncomfortable with the magistrate's order, then he can apply to a judge of the High Court of the state in which he was apprehended for a review of the order. See Section 482 subsection 3 of the CPA. The ACJA is silent on this. They compare Section 365 subsection 1 of the ACJL, 482 subsection 1 of the CPA, and sections 55 to 66 of the CPC. Given that the Federal High Court has jurisdiction over all of Nigeria, irrespective of where it sits anywhere in Nigeria, a warrant of arrest issued by it can be executed in any part of Nigeria without the need for endorsement. You may recall that we began by saying that we have what is known as a rule of law under the ACJA, ACJL, and CPA, and a rule of practice under the CPC. Section 7 subsection B of the Criminal Procedure Northern Region Act of 1960 creates the rule of practice under the CPC jurisdiction that allows Section 482 of the CPA to apply within CPC jurisdiction. These three cases are often quoted in support of execution of warrants outside state of issue. R versus Zulu, R versus Commissioner of Metropolitan Police ex parte Hammond, Matadona versus Ahu. Please take time out to consider the principles of law that these cases contain. Execution of warrants of arrest within the same state but outside the magisterial district or judicial division of issue. Please note that in this case, endorsement is not required. Let's turn attention to section 46 subsection 1 of the ACJA. Where a warrant of arrest is executed in a state outside the division or district of the court by which it was issued, the suspect shall, unless security is taken under section 45 of this act, be taken before the court within the division or district in which the arrest was made. Section 30 subsection 1 of the ACJL states, where a warrant of arrest is executed in the state outside the division or district of the court by which it was issued, the person arrested shall, unless security is taken under section 29, be taken before the court within the division or district in which the arrest was made. Section 31 subsection 1 of the CPA states, where a warrant of arrest is executed in the state outside the division or district of the court by which it was issued, the person arrested shall, unless security is taken under section 30 of this act, be taken before the court within the division or district in which the arrest was made. Execution of a warrant of arrest within the same state but outside the magisterial district or judicial division of issue and outside the state under the CPC. The precondition for execution of a warrant of arrest on an offender outside the district of issue is its endorsement by a court in the district where the offender is found. The authority for that is section 64 subsection 2 of the CPC. The transmission of the warrant of arrest from the issuing court to the executing court may be done by forwarding via post or otherwise, instead of through one or more police officers or other public servants on the one hand, and any other person or persons on the other hand. Then the executing court shall endorse the warrant and direct its immediate execution. See section 64 subsection 1 of the CPC. The transmission of the warrant of arrest from the issuing court to the executing court may be done through one or more police officers or through public or other public servants on the one hand, and any other person or persons on the other hand, and shall be taken by such person to a judge or magistrate or justice of the peace in the judicial division of execution for endorsement. And following such endorsement, it may be executed. See section 65 of the CPC. Execution of a warrant of arrest not endorsed with bail outside the district of issue. Take the arrested person to a court that has jurisdiction within the district that his arrest was effected. The court shall, in exercise of its judicial discretion, direct his removal to the issuing court, or take recognizance for bail and forward the same to the issuing court, provided that the offense that gave rise to the warrant of arrest is not a capital offense. See section 46 subsection 1 of the ACJA, section 30 subsection 1 and 365 of the ACJL, section 31 subsection 1 and 482 of the CPA, section 64 subsection 1 and 66 subsection 1 of the CPC. Destination of a person who is served a warrant of arrest. Section 43 subsection 4 of ACJA states, A suspect arrested on a warrant of arrest shall, subject to the provisions of the Constitution of the Federal Republic of Nigeria, sections 44 and 45 of this Act, be brought before the court that issued the warrant of arrest. Section 27, subsection 4 of the ACJL states, every person arrested on the warrant shall, subject to the provisions of section 29 and 30 of this law, be brought before the court which issued the warrant within a reasonable time after he is so arrested. Section 28, subsection 4 of the CPA states, every person arrested on any such warrant shall, subject to the provisions of section 30 and 31 of this Act, be brought before the court which issued the warrant as soon as is practicable after he is so arrested. Section 62 of the CPC states, the person executing a warrant of arrest shall, subject to the provisions of section 57 as to security, without unnecessary delay, bring the person arrested before the court specified in the warrant. Powers of a police officer to arrest with or without a warrant. Section 18, subsection 2 of the ACJA states, the authority given to a police officer to arrest a suspect who commits an offense in his presence shall be exercisable in respect of offenses committed in the officer's presence, notwithstanding that the act creating the offense provides that the suspect cannot be arrested without a warrant. Section 10, subsection 2 of the ACJL states, the authority given to a police officer to arrest a person who commits an offense in his presence shall be exercisable in respect of offenses committed in the officer's presence, notwithstanding that the law creating the offense provides that the offender cannot be arrested without a warrant. Section 10, subsection 2 of the CPA states, the authority given to a police officer to arrest a person who commits an offense in his presence shall be exercisable in respect of offenses committed in such officer's presence, notwithstanding that the written law creating the offense provides that the offender cannot be arrested without a warrant. Section 26A of the CPC states, any police officer may arrest any person who commits an offense in his presence, notwithstanding any provision in the third column of Appendix A that an arrest may not be made without a warrant. Does a police officer or anyone executing a warrant of arrest need to have it on him while effecting the arrest? Yes, he should have it, but even if he does not have it, it does not invalidate the arrest. That is the combined effect of reading sections 18 subsection 2 and 44 of the ACJA, 10 subsection 2 and 28 of the ACJL, 10 subsection 2 and 29 of the CPA, 26 subsection A and 61 of the CPC. Let's go through those last four sections. Section 44 of the ACJA states, a warrant of arrest may be executed notwithstanding that it is not in the possession at the time of the person executing the warrant, but the warrant shall, on the demand of the suspect, be shown to him as soon as practicable after his arrest. Section 28 of the ACJL states, a warrant of arrest may be executed notwithstanding that it is not in the possession of the person executing the warrant, but the warrant shall, on the demand by the person arrested, be shown to him within a reasonable time after his arrest. Section 29 of the CPA states, a warrant of arrest may be executed notwithstanding that it is not in the possession at the time of the person executing the warrant. But the warrant shall, on the demand of the person apprehended, be shown to him as soon as practicable after his arrest. Section 61 of the CPC states, warrant of arrest may be executed notwithstanding that it is not in the possession at the time of the person executing the warrant, but the warrant shall, on the demand of the person apprehended, be shown to him as soon as practicable after his arrest. In Maratona versus Ahu, it was held that an arrest out of state, that is, in the state where a person is hiding, and subsequent movement to another state, that is, the state where the offense was committed, and the warrant of arrest issued, without compliance with the provisions of Section 66 of the Criminal Procedure Code, was irregular. However, by virtue of Section 382 of the Criminal Procedure Code, the proceedings cannot be annulled on the basis of such a procedural error. Let's compare similar provisions in the other jurisdictions. Section 136 of the ACJA states as follows. Where a defendant is before a court, whether voluntarily or on summons or after being arrested with or without warrant, or while in custody for the same or any other offense, the trial may be held notwithstanding any irregularity, defect, or error in the summons or warrant, or the issuing, service, or execution of the summons or warrant. B. The want of any complaint on oath, or C. Any defect in the complaint or any irregularity in the arrest or custody of the defendant. Section 139 of the ACJA, a summons, warrant of any description or other process issued under a law shall not be invalidated by reason of the person who signed the summons or warrant being dead, ceasing to hold office, or have jurisdiction. Section 98 of the ACJL states, where any defendant is before a magistrate, whether voluntarily or upon summons, or after being arrested with or without warrant, or while in custody for the same or any other offense, trial may be held notwithstanding any irregularity, defect, or error in the summons or warrant, or the issuing, service, or execution of the same, and notwithstanding the want of any complaint upon oath, and notwithstanding any defect in the complaint, or any irregularity or in the arrest or custody of the defendant. Section 100 of the ACJL states, a summons or warrant or other process issued under any written law shall not be invalidated by reason of the death of the person who signed the same, or his ceasing to hold office or have jurisdiction. Section 101 of the CPA states, where any accused person is before a magistrate, whether voluntarily or upon summons, or after being apprehended with or without warrant, or while in custody for the same or any other offense, the preliminary inquiry or trial may be held notwithstanding any irregularity, illegality, defect, or error in the summons or warrant, or the issuing, service, or execution of the same, and notwithstanding the want of any complaint upon oath, and notwithstanding any defect in the complaint or any irregularity or illegality in the arrest or custody of the accused person. Section 103 of the CPA states, a summons, warrant of any description or other process issued under any written law shall not be invalidated by reason of the person who signed the same dying, ceasing to hold office, or have jurisdiction. Section 382 of the CPC states, subject to the provisions hereinbefore contained, no findings, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered on appeal or review on account of any error, omission, or irregularity in the complaint, summons, warrant, charge, public summons, order, judgment, or other proceedings before or during trial, or on any inquiry or other proceedings under this Criminal Procedure Code, unless the appeal court or reviewing authority thinks that a failure of justice has in fact been occasioned by such error, omission, or irregularity. Let us concentrate on Section 379 of the CPC. All the other sections have been addressed at some point in this video. Sections 136 and 139 of the ACJA, Sections 98 and 100 of the ACJL, Sections 101 and 103 of the CPA, and Sections 382 and 83 of the CPC. Section 379 of the CPC says in part, if any court or justice of the peace not empowered by law to issue a search warrant under Section 74 erroneously in good faith does any such thing, the proceedings shall not be set aside merely on the ground that the court or justice of the peace was not so empowered. What is the effect of failing to respond to a warrant of arrest? In other words, what is the effect of ignoring a warrant of arrest? If a warrant of arrest is issued and the subject of the same fails to respond positively to the same, then the next option available to the judge to enforce attendance is the publication of a public summons as provided for in Section 41 of the ACJA and Section 67 of the CPC. Please review our video on public summons, especially the following subtopics: when public summons is employed, execution, that is publishing of public summons or how published, and how to establish proof of publication, that is execution of a public summons. The links to those videos are provided on the current slide. LegalDictionary.net has this to say about bench warrants. A bench warrant is an arrest warrant issued by a judge or court, most commonly when a defendant fails to appear at a scheduled court hearing. This is also known as a failure to appear or FTA warrant. When a bench warrant is issued, it gives law enforcement agencies the authority to detain the defendant and bring him to court to address the issue. The purpose of a bench warrant is to deter defendants from violating court orders and to punish offenders for failing to appear as required by the courts. Bench warrants issued against prominent Nigerians include the bench warrants issued by Justice Ikonne of the Federal High Court in Lagos against the chairman of Innocent Nigeria Limited. The bench warrant issued by Elube Grade 1 Area Court against Senator Lawrence O. Ekhuchapo, who used to represent Bayelsa West Senatorial District, for failure to appear before it over a pre-election suit filed against him by Mr. Benjamin Udiwe, a chieftain of the APC in Bayelsa. The senator is now the current deputy governor of Bayelsa State. The bench warrant issued by Judge Nwaka, who presided over a Lagos High Court in Ibosere against a contractor of Lekki Gardens Estate Limited, Shola Olumofe, for failing to appear before the court on 2 consecutive occasions to stand trial in connection with a building collapse in Lekki area of the state on March 10, 2016. The bench warrant issued by Justice Danlami Senche of a Federal Capital Territory High Court against the former Attorney General of the Federation and Minister of Justice, Mohammed Adoke, a former Minister of Petroleum, Dan Etete, and 4 others over the OPL 245 Malabo affair. The bench warrant issued by Justice Buba of the Federal High Court in Lagos against Government Ekpemopolo, alias Tompolo, who failed to respond to a public summons seeking his personal appearance in court to defend himself against charges preferred against him by the EFCC. What is the connection between bail endorsement and warrant of arrest? Let's take a look at this question from the point of view of the 4 jurisdictions, beginning with the ACJA. Section 45, subsection 1 of the ACJA states, a court on issuing warrants for the arrest of a suspect in respect of a matter other than an offense punishable with death may, if it thinks fit by endorsement on the warrant, direct that the suspect named in the warrant be released on bail on his entry into such recognizance for his appearance as may be required in the endorsement. Section 45, subsection 2. The endorsement shall specify A, the number of sureties, if any, B, the amount in which they and the suspect named in the warrant are respectively to be bound, or are to provide as cash security on the request of the surety or suspect. C, the court before which the arrested suspect is to attend, and D, the time at which the suspect is to attend, including an undertaking to appear at a subsequent time as may be directed by any court before which he may appear. Section 45, subsection 3. Where an endorsement is made, the officer in charge of a police station to which on arrest the suspect named in the warrant is brought shall discharge him on his entering into a recognizance with or without sureties approved by that officer in accordance with the endorsement, conditioned for his appearance before the court and at the time and place named in the recognizance. Section 45, subsection 4. Where security is taken under this section, the officer who takes the recognizance shall cause it to be forwarded to the court before which the suspect named in the recognizance is bound to appear. Section 45, subsection 5. Subject to the provisions of Section 46 of this Act, the provisions of subsections 3 and 4 of this section shall not have effect with respect to a warrant executed outside Nigeria. Let's move to the next jurisdiction, the ACJL. Section 29, subsection 1. A court On issuing a warrant for the arrest of a person in respect of any matter other than an offense punishable with death, may, if it thinks fit by endorsement on the warrant, direct that the person named in the warrant be released on arrest on his entry into such recognizance for his appearance as may be required in the endorsement. Section 29, subsection 2. The endorsement shall specify the number of sureties, if any, b, amount in which they and the persons named in the warrant are respectively to be bound or are to provide cash security. C. Court before which the person arrested is to attend, and D. Time at which he is to attend, including an undertaking to appear at a subsequent time as may be directed by any court before which he may appear. Section 29, subsection 3. Where such endorsement is made, the officer in charge of any police station to which on arrest the person named in the warrant is brought shall discharge him upon his entry into recognizance with or without sureties approved by that officer in accordance with the endorsement, stipulating the condition for his appearance before the court and at the time and place named in the recognizance. Section 29, subsection 4. Where security is taken under this section, the officer who takes the recognizance shall cause it to be forwarded to the court before which the person named in the recognizance is bound to appear. Section 29, subsection 5. The provisions of subsections 3 and 4 shall not have effect with respect to a warrant executed outside the state. Let's move on to the third jurisdiction, the CPA. Section 30, subsection 1 of the CPA states, any court, on issuing a warrant for the arrest of any person in respect of any matter other than an offense punishable with death, may, if it thinks fit by endorsement on the warrant, be released on arrest on his entry into such recognizance for his appearance as may be required in the endorsement. Section 30, subsection 2. The endorsement shall specify a. The number of sureties, if any, b. The amount in which they and the person named in the warrant are respectively to be bound, c. The court before which the person arrested is to attend, and d. The time at which he is to attend, including an undertaking to appear at a subsequent time as may be directed by any court before which he may appear. Section 30, subsection 3. Where such an endorsement is made, the officer in charge of any police station to which on arrest the person named in the warrant is brought shall discharge him upon his entry into a recognizance with or without sureties approved by that officer in accordance with the endorsement, conditioned for his appearance before the court, and at the time and place named in the recognizance. Section 30, subsection 4. Where security is taken under this section, the officer who takes the recognizance shall cause it to be forwarded to the court before which the person named in the recognizance is bound to appear. Section 30, subsection 5. The provisions of subsection 3 and 4 of this section shall not have effect with respect to a warrant executed outside the state. We now move on to the final jurisdiction, the CPC. Section 57, subsection 1 states, a court or justice of the peace issuing a warrant for the arrest of any person shall have discretion to direct by endorsement on the warrant that if such person executes a bond with sufficient for his attendance before the court or justice of the peace at a specified time and thereafter until otherwise directed, the person to whom the warrant is directed shall, on receiving security, release such person from custody. Section 57, subsection 2. The endorsement referred to in subsection 1 shall state a. The number of sureties, b. The amount in which the sureties and the person for whose arrest the warrant is issued are to be respectively bound, and c. the time and place at which the person for whose arrest the warrant is issued is to attend. Section 57, subsection 3. Whenever security is taken under this section, the person to whom the warrant is directed shall forward the bond to the appropriate courts. Procedure for effecting an arrest under the ACJA. Step 1. Intimate the suspect that he is under arrest and provide a reason for his arrest. See section 6 subsection 1 of the ACJA. Step 2. Inform the suspect of his A. right to silence, which means that he is under no obligation whatsoever to answer any questions put to him until he has had a chance to consult either his lawyer or any other person of his choice. See section 6 subsection 2A of the ACJA. B. Inform the suspect of his right to refuse to write a statement himself and or the right to refuse to endorse any statement written for him by another and or the right to refuse to answer any question put to him following his arrest until he has had a chance to consult the legal practitioner he chooses for himself. See section 6 subsection 2B of the ACJA. Inform the suspect of his C. right to free legal representation by the Legal Aid Council of Nigeria if he so qualifies. See section 6 subsection 2C of the ACJA. Except and unless 1. The suspect was in the process of actually committing the offense. See section 6 subsection 1 of the ACJA. 2. The suspect is pursued immediately after the commission of the offense. See section 6 subsection 1 of the ACJA. And 3. The suspect has escaped from lawful custody. See section 6 subsection 1 of the ACJA. 3. Touch or confine the suspect unless he doesn't resist, that is, he willingly submits to the arrest by word or action. See section 4 of the ACJA. However, if the person effecting the arrest is of the considered opinion that A. there is reasonable apprehension of violence or an attempt to escape, see section 5A of the ACJA. B. The safety of the suspect or defendant is in issue, see section 5B of the ACJA. Or the court so directs, see section 5C of the ACJA. Then the suspect may be restrained. Procedure for effecting an arrest under the ACJL. Step 1. Intimate the suspect that is under arrest and provide a reason for his arrest. See section 3 subsection 1 of the ACJL. 2. A. Inform the suspect of his right to silence, which means that he is under no obligation whatsoever to answer any questions put to him until he has had a chance to consult either his lawyer or any other person of his choice. See section 3 subsection 2A of the ACJL. 2B. Inform the suspect of his right to refuse to write a statement himself and or the right to refuse to endorse any statement written for him by another and or the right to refuse to answer any questions put to him following his arrest until he has had a chance to consult the legal practitioner he chooses for himself. See section 3 subsection 2B of the ACJL. 2C. Inform the suspect of his right to free legal representation by the Legal Aid Council of Nigeria if he so qualifies. See section 3 subsection 3 of the ACJL, except and unless 1. The suspect was in the process of actually committing the offense. See section 3 subsection 1 of the ACJL. 2. The suspect is pursued immediately after the commission of the offense. See section 3 subsection 1 of the ACJL. 3. The suspect has escaped from lawful custody. See section 3 subsection 1 of the ACJL. Step 3. Touch or confine the suspect unless he doesn't resist. That is, he willingly submits to the arrest by word or action. See section 1 of the ACJL. However, if the person effecting the arrest is of the considered opinion that A. there is reasonable apprehension of violence or an attempt to escape, see section 2 of the ACJL. B. The safety of the suspect or defendant is in issue, see section 2 of the ACJL. C. Or the court so directs, see section 2 of the ACJL, then the suspect may be restrained. The procedure for effecting an arrest under the CPA. Step 1. Intimate the suspect that he is under arrest and provide a reason for his arrest. See section 5 of the CPA. Except and unless 1. The suspect was in the process of actually committing the offense. See section 5 of the CPA. 2. The suspect is pursued immediately after the commission of the offense. Section 5 of the CPA. 3. The suspect has escaped from lawful custody. See section 5 of the CPA. Step 2. Touch or confine the suspect unless he doesn't resist. That is, he willingly submits to the arrest by word or action. See section 3 of the CPA. However, if the person effecting the arrest is of the considered opinion that A. there is reasonable apprehension of violence or an attempt to escape, see section 4 of the CPA. B. The safety of the suspect or defendant is in issue, see section 4 of the CPA. Or the court so directs, then the suspect may be restrained. The CPC is painfully silent on the procedure for effecting an arrest. It is possible that they may have a rule of practice that mirrors what obtains in the other jurisdictions, but I did not find a definitive statement on that, and so I hesitate to post that. Are there places where no arrests can be made? In our introduction to execution of a warrant of arrest, we made it clear that it can be executed anywhere at any time within the state of issue. Although you already know this does not apply to the Federal High Court because it has jurisdiction over the entire country. This general rule admits some exceptions. Let's consider those. The first exception applies to legislative houses. At the federal level, that would include the Senate and the House of Representatives. At the state level, that would include the state houses of assembly. According to Section 31 of the Legislative Houses Powers and Privileges Act of 2018, and Tony Momo versus the Senate 1981 case, there can be no arrest in a legislative house which is in session while the house is sitting, unless the President of the Senate or Speaker of the House of Representatives or Speaker of the State House of Assembly has given permission. The second exception to that rule is the courthouse. That is an actual courtroom in which the court is sitting while that court is sitting. And the reference for that is section 43 subsection 2 of the ACJA, section 27 subsection 2 of the ACJL, and section 28 subsection 2 of the CPA. It would be an interesting academic exercise to review the statutes and case law on this issue in the light of the furor generated by the DSA's invasion of the Federal High Court premises in December 2019 in a bid to rearrest Sowore immediately after his court hearing. What is the connection between bail, endorsement, and warrant of arrest? Let's take a look at this question from the point of view of the four jurisdictions, beginning with the ACJA. Section 45, subsection 1 of the ACJA states, a court on issuing a warrant for the arrest of a suspect in respect of a matter other than an offense punishable with death may, if it thinks fit by endorsement on the warrant, direct that the suspect named in the warrant be released on bail on his entry into such recognizance for his appearance as may be required in the endorsement. Section 45, subsection 2. The endorsement shall specify A, the number of sureties, if any, B, the amount in which they and the suspect named in the warrant are respectively to be bound or are to provide as cash security on the request of the surety or suspect. C, the court before which the arrested suspect is to attend, and D, the time at which the suspect is to attend, including an undertaking to appear at a subsequent time as may be directed by any court before which he may appear. Section 45, subsection 3. Where an endorsement is made, the officer in charge of a police station to which on arrest the suspect named in the warrant is brought shall discharge him on his entering into a recognizance with or without sureties approved by that officer in accordance with the endorsement conditioned for his appearance before the court and at the time and place named in the recognizance. Section 45, subsection 4. Where security is taken under this section, the officer who takes the recognizance shall cause it to be forwarded to the court before which the suspect named in the recognizance is bound to appear. Section 45, subsection 5. Subject to the provisions of section 46 of this Act, the provisions of subsections 3 and 4 of this section shall not have effect with respect to a warrant executed outside Nigeria. Let's move to the next jurisdiction, the ACJL. Section 29, subsection 1. A court on issuing a warrant for the arrest of a person in respect of any matter other than an offense punishable with death may, if it thinks fit by endorsement on the warrant, direct that the person named in the warrant be released on arrest on his entry into such recognizance for his appearance as may be required in the endorsement. Section 29, subsection 2. The endorsement shall specify the number of sureties, if any, B, amount in which they and the persons named in the warrant are respectively to be bound or are to provide cash security. C, court before which the person arrested is to attend, and D, time at which he is to attend, including an undertaking to appear at a subsequent time as may be directed by any court before which he may appear. Section 29, subsection 3. Where such endorsement is made, the officer in charge of any police station to which on arrest the person named in the warrant is brought shall discharge him upon his entry into recognizance with or without sureties approved by that officer in accordance with the endorsement, stipulating the condition for his appearance before the court and at the time and place named in the recognizance. Section 29, subsection 4. Where security is taken under this section, The officer who takes the recognizance shall cause it to be forwarded to the court before which the person named in the recognizance is bound to appear. Section 29, subsection 5. The provisions of subsections 3 and 4 shall not have effect with respect to a warrant executed outside the state. Let's move on to the third jurisdiction, the CPA. Section 30, subsection 1 of the CPA states, any court, on issuing a warrant for the arrest of any person in respect of any matter other than an offense punishable with death, may, if it thinks fit by endorsement on the warrant, be released on arrest on his entry into such recognizance for his appearance as may be required in the endorsement. Section 30, subsection 2. The endorsement shall specify A, the number of sureties, if any, B, the amount in which they and the person named in the warrant are respectively to be bound, C, the court before which the person arrested is to attend, and D, the time at which he is to attend, including an undertaking to appear at a subsequent time as may be directed by any court before which he may appear. Section 30, subsection 3. Where such an endorsement is made, the officer in charge of any police station to which on arrest the person named in the warrant is brought shall discharge him upon his entry into a recognizance with or without sureties approved by that officer in accordance with the endorsement, conditioned for his appearance before the court, and at the time and place named in the recognizance. Section 30, subsection 4. Where security is taken under this section, the officer who takes the recognizance shall cause it to be forwarded to the court before which the person named in the recognizance is bound to appear. Section 30, subsection 5. The provisions of subsection 3 and 4 of this section shall not have effect with respect to a warrant executed outside the state. We now move on to the final jurisdiction, the CPC. Section 57, subsection 1 states, a court or justice of the peace issuing warrants for the arrest of any person shall have discretion to direct by endorsement on the warrant that if such person executes a bond with sufficient for his attendance before the court or justice of the peace at a specified time and thereafter until otherwise directed, the person to whom the warrant is directed shall, on receiving security, release such person from custody. Section 57, subsection 2. The endorsement referred to in subsection 1 shall state A, the number of sureties, B, the amount in which the sureties and the person for whose arrest the warrant is issued are to be respectively bound, and C, the time and place at which the person for whose arrest the warrant is issued is to attend. Section 57, subsection 3. Whenever security is taken under this section, the person to whom the warrant is directed shall forward the bond to the appropriate courts. This brings us to the end of our consideration of arrest with a warrant under Nigerian criminal law. The next video, that is lesson 3, part 3, subpart 4, is the final and concluding part of this series of video lectures under the series Searches, Summons, Arrest and Rights, as well as Safeguards for an Accused Person. And it will focus squarely on rights and safeguards for an accused person.